Hello everyone and welcome to my channel Law and Key. Over here, the coming next few months, I'm going to cover judgments and help you analyze those judgments which are important from the perspective of CLAT PG 2025. I'm going to start with Supreme Court Constitutional Bench judgments because those are important as well as hold a lot of weightage. Along with that, I'm going to help you understand the terminologies, what kind of questions are asked in the exams. So get your pen and paper ready and let's start. In today's video, I'm going to cover one Supreme Court judgment, a very recent one and very important one from the perspective of CLAT 2025. So without any further ado, let's start. The judgment we are covering today is High Court Bar Association Allahabad versus State of Uttar Pradesh. It's a Supreme Court 5-bench judgment. The bench comprises of CJI D.Y. Chandrachud, Justice Mr. Abhay S. Oka, Justice Mr. J.V. Bardwala, Justice Mr. Manoj Mishra, and Justice Pankaj Mittal. I'm telling you the name of judges because the question can come from here as well. So the issue that was covered in this judgment was whether an interim order can come to an end automatically due to lapse of time. So what was held in this judgment? In this, it was held that the Constitutional Court should not typically impose a time limit to dispose of a case pending in any court. A stay order granted in civil and criminal cases will remain in operation till the case is decided unless it is expressly time bound. So let's first understand the factual background of the case. So this case, by an order dated 1st December 2023, a bench of 3 honorable judges of this court expressed a view that a decision of this court in the case of Asian Resurfacing of a Road Agency Private Limited and another versus Central Bureau of Investigation requires reconsideration by a larger bench, right? So first let's understand what was held in this case. The court held in this case that the order of framing of charges was neither an interlocutory order nor a final order. Therefore, it was held that the High Court has jurisdiction in appropriate cases to consider a challenge to an order of framing of charges. Furthermore, the High Court has jurisdiction to grant stay of the trial proceedings. Now, before moving forward, let's understand what is interlocutory order and interim order, right? It's a very basic question, but a lot of people do not understand the difference between two, and sometimes question can come from these terminologies as well. So an interlocutory order only decides a particular aspect or a particular issue in a proceeding, suit or a trial which is pending before the court, however does not conclude the main controversy of the case. Other hand, interim orders do not determine the substantive rights and liabilities of the parties with regard to the subject matter. Okay, so now we can move forward. So the court further held that at times proceedings are adjourned sine die on account of stay. Right, we have seen that in court that even after the stay is vacated, sometimes the intimation is not received and the proceedings are not taken up. And so the court, in an attempt to remedy this situation, considered it appropriate to direct that in all pending cases where stay against a proceeding of a civil or a criminal trial is operating, the same will come to an end on an expiry of 6 months from today or as the date of the judgment, unless in an exceptional case by a speaking order such stay is extended. And in cases where a stay will be granted in the future, the same will end on an expiry of 6 months from the date of such order unless similar extension is granted by a speaking order. The court further held that the speaking order must show that the case was of such exceptional nature that continuing the stay was more important than having the trial finalized. So the court, what essentially did over here was give us the deadline of 6 months to complete 6 months to vacate the stay, right? If in 6 months the controversy of interim nature is not decided, then the stay will get vacated automatically. This is done with the intention of reducing the pendency of the cases or delaying of the cases, and this is the challenge, or this is the issue that was referred to a larger bench. So what were the issues framed? There were 2 issues framed by the court. So the court framed 2 questions. The 2 questions are, first, whether this court in exercise of its jurisdiction under Article 142 of Constitution can order automatic vacation of all interim orders of the High Court of staying proceedings of civil and criminal cases on expiry of a certain date. So essentially, whether an automatic vacation or stay can be granted or not under 142. And second, whether this court in exercise of its jurisdiction under Article 142 can direct the High Court to decide pending cases in which interim orders or stay proceedings has been granted on a day-to-day basis and within a fixed period, right? So let us understand what was the submissions of the parties and what was analyzed. So now let's move on to the analysis by the court, right? So the first thing that the court ventured into is the objective of passing interim orders. So the court held that an occasion for passing an order of stay of the proceedings normally arises when High Court is dealing with a challenge to an interim or interlocutory order passed during the pendency of the main cause before a trial or the appellate court. So the High Court can grant a relief or stay of hearing of the main proceedings on being satisfied that a prima facie case is made out for granting such stay. So while passing an order of interim order of stay, the three factors are considered by the courts. First, the prima facie case should be made out. If the stay is not granted, the party will suffer irreparable loss and the balance of convenience, right? These are the three factors which are considered by the court while granting interim order of stay. The court further held that when the High Court is passing an interim order of stay, it is considering factors like prima facie case, irreparable loss, and balance of convenience, right? As I told you earlier. So there is an application of mind. So while vacating such an interim order or modifying such an interim order, the court still has to consider or give an opportunity to both the parties to make their cases and then apply. There has to be an application of mind by the court, and then an order of vacation can be passed. It cannot only be passed because of expiry of a certain period of time which has as held in Asian resurfacing, because that will be contrary to the concept of fairness. Right. The court further held that a legislature attempted to provide for an automatic vacation of stay granted by the Income Tax Appellate Tribunal by introducing third provision to section 254(2)(a) of IT Act. It provided that if an appeal in which the stay was granted was not heard within a period of 365 days, it would amount to the automatic vacation of stay. Right. In the case of Pepsi Foods Limited, this court held that a provision automatically vacating a stay was manifestly arbitrary and therefore violative of Article 14 of the Constitution of India. So now, why was this third proviso to section 254(2)(a) of the IT Act was held unconstitutional? It is because it does not factor in whether or not the assessee is responsible for the delay caused in the hearing of the appeal, and further whether the tribunal could not take up the appeal in time and there was no fault of the assessee. While considering all of these factors, the court concluded that an interim order passed after hearing the contesting parties cannot be vacated by High Court without giving sufficient opportunity to be heard to the parties whose prayer for interim relief has been granted. Even if the interim relief is granted after hearing both the sides, as observed earlier, the aggrieved party is not precluded from applying for vacating the stay on the grounds that are available, like there is a delay, the opposite party is intentionally delaying the proceedings, and grounds like that. Further, the court held that application for vacating interim reliefs cannot be kept pending for an inordinate long time. The High Court cannot take recourse to the easy option of directing that the same should be heard along with the main case. Next, the court considered the scope of exercise of powers under Article 142 of the Constitution. Now, what is Article 142 of the Constitution? The Article 142 of the Constitution, the Supreme Court has been given the power to pass an order or a decree as is necessary for doing complete justice in any case or matter pending before it, and any decree so passed or order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by the Parliament, right? So the court held that a direction that all interim orders of stay proceedings passed by every High Court automatically expire only because of lapse of time cannot be issued in exercise of jurisdiction of this court under Article 140 of the Constitution, and further held important parameters for the exercise of jurisdiction under Article 142, and those are and as follows. First, the jurisdiction can be exercised to do complete justice between the parties before the court. It cannot be exercised to nullify the benefits derived by a large number of litigants based on judicial orders validly passed in their favor who are not parties to the proceedings before this court, right? And second, that Article 142 does not empower this court to ignore the substantive rights of the litigants. It is there for doing the substantial justice between the parties, but it cannot ignore the substantive rights of the litigants. Third, while exercising the jurisdiction under Article 142 of the Constitution, court can always issue procedural direction to courts for streamlining procedural aspects and ignoring out the and ironing out the creases in the procedural laws to ensure expeditious and timely disposal of cases. However, while doing so, this court cannot affect the substantive rights of those litigants who are not parties to the case before it. The right to be heard before an adverse order is passed is not a matter of procedure but a substantive right. With this, we have come to the end of the video. Please let me know in the comment section if you have any more doubts with respect to this judgment or anything that you would want me to take up next. Please do comment. Thank you.